Excuse me. Excuse me.
Hello, everyone. A very good morning to all those present here today. Welcome to our panel session, held in conjunction with UM Consti Team's Virtual Constitutional Carnival 2022. Stop the Hop is Anti-Hopping Law the Solution Forward, a collaborative effort of the UM Consti Team and the Bar Council's Constitutional Law Committee. For everyone's information, the Consti Carnival is an annual flagship event organized by the UM Consti Team that spans a period of a few weeks. Under the Carnival, events and competitions revolving around constitutional law are held in order to promote and celebrate the spirit of constitutionalism. To start things off, allow me to introduce myself. I am Brian L. Tan, your MC for today. Before we begin with today's panel session, I would like to remind all participants of a few housekeeping rules in order to ensure a smooth sailing session ahead. First, kindly ensure that your cameras and microphones are turned off at all times in order to avoid any interference or disturbances during the session. Second, should you have any questions that you would like to pose to any of our esteemed speakers, you may submit them in the chat box. Or for those tuning in via our Facebook live stream, you may drop your queries in the comment section. The moderator may then direct your questions to the speakers during the Q&A session later. You may also pose your questions to the speakers directly by clicking on the raise hand feature. When the moderator calls out your name, you may then turn on your cameras and microphones and ask away. I would also like to remind everyone that screenshots will be taken throughout this event for record purposes. Our panel session today will commence with a moderated panel session, followed by a Q&A session. Now, before we begin with the panel session, allow me to introduce you to the panel for today's event. We are extremely honored to have with us two esteemed speakers from the Bar Council's Constitutional Law Committee. Allow me to provide a brief introduction. We are thrilled to introduce Mr. Nimalan Devaraja, a dispute resolution partner at Skrine. He primarily practices in the areas of civil and commercial litigation, company law and shareholders disputes, international arbitration, restructuring and insolvency, and regulatory enforcement. He is a contributing editor to the Annotated Statutes of Malaysia Limitation Act 1953 and Partnership Act 1961, and the Malaysian Court Practice Trial Courts. Next, we are delighted to introduce Mr. Joshua Wu Kai Ming, an advocate and solicitor of the High Court of Malaya. He was called to the bar in 2019 and has been a member of the Bar Council's Constitutional Law Committee since the 2018-2019 term. Mr. Joshua is a civil litigator and is passionate about the administrative law and constitutional law. He has published several journal articles and contributed to several state bar magazines. Mr. Joshua also regularly publishes articles on various legal topics on his personal website at joshuawu.my. As for our moderator today, we are pleased to have with us UM Consti Team's very own advisor, Dr. Sheila Ramalingam. Dr. Sheila is a senior lecturer at the Faculty of Law, Universiti Malaya, and a non-practicing advocate and solicitor of the High Court of Malaya. Her areas of expertise include the Malaysian legal system, constitutional law, tort, and environmental law. She is also a member of the Constitutional Literacy Initiative, CLI, which is a collaboration between the Malaysian Bar and the Faculty of Law, Universiti Malaya, that aims to promote and champion constitutional literacy across all members of the general public. Now, without further ado, we shall begin our panel session. I shall pass the floor to the moderator, Dr. Sheila.
Thank you, Mr. Brian. So hello and welcome everyone to this panel session entitled Stop the Hop, Is Anti-Hopping Law the Solution Forward? So first of all, before we begin, I would just like to say thank you and congratulations to the Universiti Malaya Constitutional Team for hosting and organizing this event, touching a very important and quite a critical topic plaguing Malaysia at the moment. Secondly, I would also like to thank our two distinguished speakers today for taking the time off their busy schedules to share their wisdom and insights on this topic with us. And lastly, I would like to thank all of you for attending this panel session today. Your attendance and presence today makes all the difference on this beautiful Saturday morning. Okay, so a little bit about party hopping first. Party hopping has got many names. It is also known as party switching, floor crossing, or parliamentary defections. Party hopping calls into question the sanctity of the people's vote and choice at the election. The end result of a vote for any candidate would be the formation of the government by the political party whose candidates win the most number of seats. That is the thrust of every democratic process, including our own. It follows that when a government can be changed by several elected representatives hopping from an elected government to the opposition, the democratic process whereby our government is chosen and formed is rendered illusory and a mockery. When a new government could be formed by an opposition who has actually lost the election by virtue of the hopping, the whole foundation and premise of that new government is the betrayal of the people's votes and choice. Hence, the call by various parties, including the Malaysian Bar, for anti-hopping laws to deter the phenomena of hopping. This can be by way of either constitutional amendments or by ordinary laws. When an elected representative hops to another party, whether or not that leads to a change in government at federal or at state level, should that elected representative be penalized for his or her actions? Should his or her seat be vacated and a by-election called? Should the people be given the mandate to vitiate the hop by calling for recall elections? These are some of the issues that we hope to cover in our panel session today. So for starters, let me ask our speakers their opinions on this. In Malaysia, does the voter vote for the candidate as an individual or for the party which the candidate represents? What do you think?
Should I go first, Joshua, or do you like?
Sure, Nimalan, please.
I think it varies really. I know a lot of Malaysians who vote for a party. They don't know their candidate. They just stick whether they see the touching or the rocket or the eye. And I think there's always, I remember back in 2008 elections, which I was following, there's always the story of you could put a goat with the Pakatan Rakyat PKR flag and people will still vote for it. Having said that, on the other hand, you do have situations like, well, I can remember in 1999, Pematang Pahau, which was an UMNO stronghold, voted for Dr. Wan Aziza because she was the wife of their longtime MP, Anwar Ibrahim, and they have stayed strongly with the Anwar Ibrahim family all the years. Going back to the 80s, you have YB Shahid Samad, who left UMNO, resigned as an MP, and stood for elections again and won. So I do think it really depends. The sentiment I get nowadays is a lot of people vote for the party first, but there are definitely individuals who seem to transcend their parties. Joshua?
Yeah, I completely agree with Nimalan. I think legally, of course, you're voting for the candidate. But realistically, I think a lot of people vote for the party. And sometimes, like Nimalan mentioned, they don't even know who the candidate is. You know, they just they recognize the party flag and then that's good enough for them. But I think legally, they should be voting for the candidate.
Okay, thank you. Do you think party hopping is part and parcel of party politics?
Yes and no. And I think I distinguish it like this. I think you should have the freedom to associate whichever party you want. And I think we see that in Malaysia, there are numerous individuals who keep jumping from party to party. Having said that, I do think if you're an elected representative, there is a bit of a difference there. If you are elected based on a party ticket or a party mandate, then I don't think you should be hopping. So that's where I draw a line, I guess, on whether you are a normal Malaysian, even if you're a party leader, or whether you're an elected representative.
Okay, and what about Mr. Joshua?
I think realistically, it is part and parcel of party politics. But I think many of us don't want it to be that way. And I think ideally, it would be great to have a society with integrity where someone who runs on a particular ticket, if let's say they no longer share the ideals of the party, then of course they resign, vacating their seats, so on and so forth. But the reality is not the case. So as much as we don't want party hopping to be part of party politics, I think it realistically is part and parcel of it.
Okay. So then would you say that generally the phenomena of party hopping is a part of freedom of association? And so that necessarily then includes the freedom to disassociate.
Joshua, do you want to take this first?
Yeah, okay. I'd like to request for UMCT to share screen slide 13 of my slides. So the issue of anti-hopping law has actually cropped up before. The Kelantan State Legislature passed a specific constitutional amendment. And then when it went up all the way to the Supreme Court, this is what the Lord President then said. The right to form an association under Article 10(1)(c) of the Federal Constitution also includes within its suite the right to disassociate from an association. So to answer Dr. Sheila's question, if you ask Tun Abdul Hamid Omar, his answer is yes. I think it is not something that has a general consensus. I think crossing the floor is a very common phenomenon, but then we all disagree on whether it forms part of freedom of association. If we look at the slide number 3. Okay, slide 3. Yeah, slide 3 is basically a table compiled by a researcher. This table was compiled in 2009, but it's a bit outdated because the countries considered inside were as of 2007. But we see that about 41 countries have floor crossing laws. So at least in relation to these countries, they would say that the freedom to disassociate is not included in the freedom of association. But then again, many other countries do not have such restrictions on disassociating. So I think one thing that we can say for sure is that the freedom of association is not an absolute right. We can see this in Article 10(2)(c) of the Federal Constitution. If you could help me share slide number 8. Yeah, so slide 8 is Article 10(1)(c), which says that all citizens have the right to form associations. This is a general rule. And the next slide. This is Article 10(2)(c), which is an exception, which says that Parliament may by law impose restrictions as it deems necessary or expedient in the interest of the security of the Federation or any part thereof, public order or morality. So I think now the discussion is whether anti-hopping laws would fall under any of these 3 exceptions. And I think we'll be discussing this further later.
Yes, we will. We will go a little bit deeper into the Nordin Saleh case and Article 10 of the Federal Constitution a bit later. But for starters, I just wanted to get a feel on how you feel about party hopping. Can you say that it is a right to associate, which includes the right to disassociate, and therefore it is something which is allowed or should be allowed? Or do you think that there are ways to get around it?
The way I see it is that even if the freedom to disassociate is included within the freedom of association, by virtue of the freedom of association not being an absolute right, there can be restrictions and limitations to the freedom to disassociate.
Okay, thank you. How about Mr. Nimalan?
Yes, so I think I echo what Joshua says. I think the federal court got it right that right to associate must include right to disassociate. You can't just force someone to stay in an organization or party if they don't want to. But the Constitution has allowed for certain exceptions to that, public order, public morality, and I do think in elected representative case, this would arguably fall under that. So you have a right to disassociate, but it's not a complete freedom.
Okay, so where would you draw that line? Because you say it's not a complete freedom, right? So in what instances would you say that, okay, in this case, hopping is allowed, but in these cases, hopping is not allowed? How do you distinguish?
So I go back to what I said, I guess, at the start, I think if you're just a normal member, or even if you hold a leadership position in the party, you can hop. I mean, that is still hopping parties. But if you are elected on the ticket, or as a representative of the party, or as a representative of people based on the party ticket, you then can't hop without, at the very least, running the risk of losing your seat and having an election called.
Okay. Mr. Joshua, do you have anything to add?
No, I agree with Nimalan as well.
Okay. Okay, so now let's come to the crux of the matter, which is, do you think anti-hopping laws should be implemented in Malaysia? Or do you think there are other better ways of handling this situation of hopping without amending either the federal constitution or introducing a new law on anti-hopping?
I don't think, well, whether anti-hopping law is the best way, I think that's 50-50. It's either anti-hopping laws or, as YB Azalina tried to push for at one time, recall elections. But I think coming to your question, one, I do think to be safe, we should have a constitutional amendment. I mean, why run the risk of someone challenging this all the way up to the federal court again? Especially if both sides of the floor, for now at least, seem to say that they want some form of anti-hopping law enacted. Is there a way around it? Arguably, yes. Having elected representatives who are of integrity and who will stay loyal to the people and the party that they voted on. But unfortunately, as we have seen, I think at least for the past 13 to 15 years, that's a bigger dream than any of us can wish for.
Yes, Mr. Joshua?
I think I'm in favor in principle of some sort of anti-hopping law, but I think it really has to be studied in depth. For example, the scope of anti-hopping. How are we defining the scope? Is it only when you switch from party to party? What about when you switch from party to independent? What about does it include cases of when an elected representative is kicked out of the party? So there are all these different scenarios which require, I think, further discussion, because if not, we can have an anti-hopping law, but it has so many loopholes that it is ineffective. And it basically defeats the purpose of having such a law, because, politicians will just capitalize on the loopholes and then say, oh, there should not be a need for elections. I didn't fall under the limited circumstances in which it amounts to party hopping, for example. Like in terms of alternatives, I think Nimalan has mentioned it, but I think that's the ideal scenario. We know realistically such MPs are few and far between. I'm also in favor of a constitutional amendment, but I recognize that it is easier said than done. I think it's definitely going to require two-thirds majority, and regardless of what politicians are saying, we're in favor of it. A lot of them have benefited from party hopping. So I think when push comes to shove, unless it's actually tabled in Parliament, I don't think they will, they'll actually really introduce something like a Constitutional Amendment Act to prohibit anti-hopping.
Okay, thank you. So now I want to move on to some of the advantages of having anti-hopping law. So one advantage, of course, is that if there is an anti-hopping law, it gives rise to a more stable government, because you will have the elected representatives that you have voted for, and they are the ones who are given the mandate to form the government. And it will be quite stable, because there will not be so much hopping, because there are laws in place that deter this phenomena of hopping. So there is no doubt that a stable government, legitimately voted by the people, would bring about political, economic, and social strength to the nation. Party hopping tends to destabilize a government, with the domino effect of causing political, economic, and social chaos. Anti-hopping law seems to be the best solution to maintaining a stable government, one of the people, by the people, and for the people, to borrow the words of Abraham Lincoln. However, looking at the recent incidents in Malaysia and various by-elections that have happened since 2018, some have propounded that party hopping did not really play a significant role in affecting economic growth. One economist, Mr. Rana, said factors like the prolonged duration and tightness of the lockdown affected Malaysia's economy more than the party hopping and by-elections. Would you agree with this?
Do you want to go first, Joshua? Or
Yeah, sure, no problem. I think that's a very good question. I think we can safely say that both political instability and the lockdowns affected Malaysia's economy, but it's difficult to say with absolute certainty which one affected more and which one played a more significant role. I think if we look back in 2020, that was when the Sheraton move occurred. That was in February. And then in March, we had the first MCO. So it's difficult to conclusively say which one had a greater role. It could have been political instability. It could have been the lockdowns. It could have been a combination of both.
So, I mean, I would, for purely economics perspective, I would agree with Vishnu Rana that, you know, it's likely the prolonged direction and tightness of our lockdown affected the economy more, because people just couldn't operate, people just couldn't carry out their business. But having said that, I do agree that political instability does affect the economy substantially, because one, if looking at the point of a foreign investor, even a domestic investor, do I want to invest in a country which, you know, any day they could just change government and bring in new policies which you have no idea about? So definitely having a stable government helps. And two, I think we've just seen for the past 2 years, even during this prolonged lockdown, our newspapers were filled with news of political instability day after day. And it seemed like our leaders were busying themselves half the time with trying to get power or trying to unstabilize the government instead of focusing on the economy and the lockdown. And we don't know how much of the government's policies in itself were influenced by this, as opposed to trying to recover the economy. So I think it definitely does have a huge impact on the economy.
Okay, thank you for that. Some have also opined that anti-hopping laws strengthens parliament, as bigger parties are thwarted from attempting to lure smaller parties or independent MPs, for that matter, in exchange for reward. So do you think anti-hopping laws would prevent MPs from simply becoming friends or allies of the other political parties, therefore indirectly joining the coalition?
I think it depends on the scope of hopping, you know, because I think when most people, when we talk about party hopping or anti-hopping, they think about switching from one party to another. There's no discussion about coalitions. So I think it still doesn't, it may prevent a bigger party from stealing MP from a smaller party, but it doesn't prevent a coalition or a larger party absorbing or forming a new coalition with a smaller party.
I think I agree with Joshua there. I mean, I don't think by formulating anti-hopping laws, you prevent people from associating with others or bipartisan efforts. I think we've seen that even in the recent, even in the last 2 years, we've seen, I think, the opposition, Pakatan Harapan, has signed an MOU with the government. Dato' YB Azalina has been pushing a very strong bipartisan effort to get recall elections passed. And I do agree with the concept that I think if you're elected, you shouldn't always have to vote by your party lines. You should be allowed to vote with your conscience. And I do recall, I think the UK allows this, and I'm just looking it up. I think there is that they have a position where you can, on certain motions, elected representatives are allowed to cross the floor and vote against their party or against their government if they don't believe in the motion. So I think we should start seeing that more in Malaysia. I think in Malaysia we are very forced, I guess, to say elected representatives are forced to vote for or against depending on what their party wants. And I don't think that should be the case for all motions. Only the really important ones, say for example the budget. I think more often than not, we should be allowing our representatives to vote according to what they believe is the best policy.
Mr. Joshua, do you have anything to add?
No.
Okay, so talking about the coalition, I'm slowly coming to my next point, which is looking at the example of the political crisis that occurred in 2020 in Malaysia. There is really a point to be made about the extent of anti-hopping laws, because in that year, the crisis occurred not because individual MPs switched parties, but rather because an entire party moved from one coalition to another. But individual MPs still remained loyal within their parties. So given this context, what should be the extent of anti-hopping laws implemented in Malaysia? Should it be only to punish individual MPs from moving between parties, or do you think it should be extended further to encompass political parties shifting coalitions as well?
Where I can go first, I think it really depends on what ticket you're elected on. And I think people forget when they use this, when they raise this question, that in actual fact, all of the MPs of Pakatan Harapan at the time were elected on the PKR ticket. So strictly speaking, if you're leaving PKR or you're no longer supporting PKR anymore, you are leaving the ticket that you were voted on, regardless if you still remain formally on the Bersatu platform. So I do think it comes back to what was the ticket you were voted on. And if whether you voted as the PKR ticket or, as you've seen recently, Pakatan Harapan or Barisan Nasional ticket, if you leave that coalition, regardless of whether you stay on the party or not, then I take the view you should be resigning or being subject to a recall election, because that was what the voters voted on, the coalition or the party ticket, not so much your individual formal party.
Okay, so Mr. Nimalan, what you're saying is the anti-party hopping law should not only govern individual MPs who leave their own parties, but also those MPs who are leaving the coalition.
Yes, correct.
Okay, Mr. Joshua, do you agree with this? Or do you think it's too far?
Yeah, I think there's no easy or clear-cut answer. I think it's a very good question. And if we see from the Sheraton move, Bersatu, an entire party left Pakatan Harapan. And I echo what the Minister and the Prime Minister's Department for Parliament and Law said. There's no consensus on the definition of anti-hopping. And here we see a very good example. I'm just thinking, if we extend the scope of anti-hopping law to include coalitions, then I think we'll have an issue. We have to consider what happens if the coalition kicks an entire party out. For example, let's say hypothetically Pakatan Harapan kicked Bersatu out, then will all the Bersatu MPs lose their seat? Yeah, I think it is a bit extreme and a bit, there needs to be a lot of fine-tuning before we we extend the scope of anti-hopping to parties leaving coalitions. I think even in terms of individual MPs or aduns leaving their party, there's already a huge disagreement and no consensus.
Yes, Mr. Nimalan, do you want to rebut what Mr. Joshua said?
No, I mean, I agree it's very drastic, but I mean, I take the position that, you know, if I vote for a particular ticket and you leave the ticket, you should at the very least re-stand for your seat and let me decide whether I still want you or not.
Okay. Okay, so what do you think are the social or even legal barriers surrounding the enactment of an anti-hopping law?
Joshua, do you want to go?
Yeah, okay. For social, I think only certain segments of the public are clamoring for it. We don't see unanimity or the public overwhelmingly supporting it. For example, in the case of abolishing GST, Pakatan Harapan ran on it in the 2013 elections, I think, and they really just hammered home that point, got a lot of public support. So I think politicians being politicians, if the people really wanted something like anti-hopping law, I'm very certain that politicians will push it through. So I think there needs to be social acceptance or social demand for anti-hopping law. So at the moment, we don't have that. I think certain maybe more liberal or more progressive MPs or individuals or parties are pushing for that. Legal, I think it will be the Nordin Saleh decision. I'm not sure if Dr. Sheila want to discuss it now.
Yes, in a while after we hear from Mr. Nimalan.
I mean, I agree with Joshua. I think the social is people, the general population at least, are not pushing for it because I think they're also suffering from election fatigue and people jumping from party to party. They've just gotten, I guess, tired of it all. And I think we've seen that even in the recent, say, elections and by-elections, where the proportion of voters are dropping. So I think people are not clamoring for it because they feel at least it does not affect their lives directly. Unlike, for example, the GST issue that Joshua brought up, which actually impacts me directly. I think Malaysians have now reached a point where we feel, whichever party is there, my life is not going to change anyway. So I don't think there's a push for it, one. And two, I think the cost of having the elections, whether a recall election or a fresh election based on anti-hopping laws, is an issue that we'll have to look into whether it is cost prohibitive or not. I think legally the biggest issue would be the Nordin Saleh decision by the Supreme Court, which is presently under challenge in some form or another based on the Penang, the challenges in Penang.
Okay, I agree with what both of you said, which is that if you look at the recent by-elections and state elections, the trend seems to be that the number of votes have really dropped. But wouldn't you say that this in itself is like a call by the people that they are fed up with all these politicians hopping and they want a change? It may or may not be an anti-hopping law, but they want a change. And the way that they are showing this is by rebelling and not going out to vote anymore, because they say, what's the point? I vote, tomorrow you jump. And then see, there's no point. So can you take that they are not coming out to vote as a social factor that people want to change? Can you look at it that way?
If I may go first, I think yes. I think the low turnout is partly due to people, as you say, Doctor, are just being fed up. I make a vote and then the next day you jump. So there's definitely that social protest going on. Or whether the cure for that is an anti-hopping law, I don't know for that particular point, just because, again, it comes to it, right? I vote for you, you jump, and then now I have to vote again. Am I just sick of that? How often do I have to vote? I do think the people will like a bit more policy where once I vote for you, you cannot hop for the next 5 years. But unfortunately, I think that may be a stretch too far for the legislators to do. So it's a balance that has to be struck.
Okay. Mr. Joshua, would you like to add anything?
Yeah, I think like Dr. Sheila, as you pointed out, I think definitely we can draw some inferences from the fact that some people are not going out to vote. But I think unless we're talking about overwhelming majority of people not going out to vote, for example, only 20% turnout, I don't think that is strong enough a message to the elected representatives. And even if it's a 20% turnout, as long as a particular ADUN or MP gets the majority of that 20% votes, then they still win the seat. So I don't think they're really bothered by the turnout. In fact, it may favor certain parties.
Yeah. Okay. Thank you for that. Okay, so now we come to this celebrated Supreme Court decision of Nordin Saleh in 1992. So in this case, it was held that the freedom of association guaranteed in Article 10(1)(c) of the Federal Constitution includes the right to disassociate. Therefore, the anti-hopping law in Kelantan, which was the issue in that case in Nordin Saleh, the anti-hopping law in Kelantan was held to be unconstitutional, as any restriction to disassociate from an association would make the guaranteed right ineffective and illusory. This was the decision of the Supreme Court. So my question is, how would it be possible for Parliament to enact an anti-hopping law in light of this Supreme Court decision?
The safer method would be by way of constitutional amendment. Yeah, I think once we amend maybe Article 10(2)(c) and or Article 48, I think, yeah, then we should be able to sidestep Nordin bin Saleh. But if we go by way of an ordinary act of parliament, Nordin bin Saleh's decision will bind, up until the federal court, although the federal court can depart on the basis that the decision is now wrong, uncertain, unjust, outmoded, or obsolete.
I agree with Joshua. I think the easiest way is to have constitutional amendment. Having said that, Nordin Saleh also didn't really look at the exceptions to allow the Article 10(2). If I recall correctly, the Supreme Court there just said that it is of Parliament to impose such restrictions, and it's not left to the state assemblies to do so. I'm putting aside whether that is correct or not. In this case, you're looking at Parliament themselves enacting the restrictions, enacting the anti-hopping law. So I think you may be allowed to get around that finding of Nordin Saleh and then open discussion of whether an anti-hopping law does fall into the exception of public order or public morality.
Okay. Yes, you are actually right, Mr. Nimalan. If you look at Article 10(2)(c) of the Federal Constitution, it does provide that Parliament may by law impose such restrictions as it deems necessary or expedient in the interest of the security of the Federation, public order, morality. And in the Nordin Saleh case, one of the reasons as to why the anti-hopping law in Kelantan was struck out was due to the lack of state legislative competence in enacting such law. So this brings me to my next question, which is, if Parliament was the body enacting an anti-hopping law, would federal legislative competence be enough of a reason to distinguish from Nordin Saleh? In other words, would the legislation passed by a simple majority of the Parliament be enough to come under the ambit of Article 10(2)(c) of the Federal Constitution?
I can go first. Can I request UMCT to help me share screen slide 12 of my slides? Yeah, slide number 12. Yeah, so this is another extract from the decision. I think it is correct to say that in Nordin bin Saleh, they were considering the Kelantan state constitution. So I think the primary reason why the Supreme Court found that it was unconstitutional was because the state didn't have the legislative prerogative to introduce such a restriction. However, I think, if I'm not mistaken, from this extract, we can also see that the Supreme Court also did consider whether or not such a provision, legislative competence aside, would fall under the exceptions in 10.2c. So Tun Abdul Hamid Omar, Lord President, held, I cannot by any stretch of imagination see how such a restriction on the membership of a legislative assembly, which infringes the citizens' right to form associations under Article 10.1c of the Federal Constitution, can be deemed necessary or expedient in the interest of Malaysia or any part thereof, public order, morality, or even labor or education. So I think Nordin Saleh is definitely a big hurdle, because they not only considered the issue of legislative competence, but they also considered the constitutionality of anti-hopping law in light of the exceptions to Article 10.1c. So an ordinary act of parliament, when challenged in court, I'm of the view that it will fail all the way up until the federal court. Whether or not the current federal court will agree with Nordin Saleh or will distinguish Nordin Saleh, I can't say for sure what will be the outcome.
Okay, so if I understand correctly, Mr. Joshua, you are saying that that excerpt that you just read just now from the Nordin Saleh case, you are saying that the Supreme Court has basically said that even if Parliament made an anti-hopping law, it would not fall under the restriction in Article 10.2c of the Federal Constitution. Is that right?
Yes.
Okay, Mr. Nimalan, do you agree with Mr. Joshua?
I mean, I do agree to the extent that that is what that Supreme Court said. Well, so was it Justice Hamid who said that in his decision? Whether I agree with his decision or not on that particular issue is a different story. And I do agree, Joshua, that I think we're looking at the federal court having to decide this. And the easier way around it is to just get a constitutional amendment once and for all, so that there's no ambiguity. But coming back to what Joshua said earlier on the difficulty of getting a constitutional amendment passed, I disagree. I think if there's political will, we can get it passed, since both sides have publicly at least said that they are agreeable to some form of anti-hopping law. So I think if you're agreeable to an anti-hopping law being enacted, putting in a constitutional amendment to allow for it is really the smallest step. Once you have that amendment in place, you can then discuss the details to go into an actual bill.
Okay. Okay, so now talking about constitutional amendments, I know both of you all have said that Article 10 needs to be amended, but let me ask you this. Would it be better if there was added in an additional clause in the Federal Constitution to the effect of what we have in Singapore and India, to say that if an elected representative leaves his party on which he won the election, his seat is then automatically vacated and a by-election has to be called. So basically what I'm suggesting is we keep Article 10 as it is, don't amend, but we have this additional clause in the Federal Constitution saying what will happen if an elected representative leaves the party that he won the election in. What do you think about this suggestion? Would it circumvent Nordin Saleh? Or do you think it will still get stuck with Nordin Saleh?
I'll go first. I think I'm definitely in favor of that. I'm in favor of a constitutional amendment, but it doesn't have to be Article 10.1 or 10.2. It can be in Article 48, which talks about automatic disqualification. We just put it there. If you leave your party, or then good enough lah. So definitely a constitutional amendment is ideal. Article 48 is one of it. If it was up to me, I would say let's just amend 10.2c. Maybe we create another exception on top of public order morality. But even if we don't amend 10.2c, we amend 48, then I think based on the doctrine of harmonious construction, it shouldn't be an issue about the constitutionality of this amendment to Article 48.
I strongly agree, Joshua. I think we both on, well, all three of us are at least on, well, both of us at least are on common footing that there needs to be a constitutional amendment, whether it's done to Article 10.2, whether you insert an Article 10.3, or whether you amend 48. I think it can go either way, really, as long as there's something inside there that allows for it.
Okay, thank you very much for your opinions. Just that I'm one of those who am very wary about amending a fundamental liberty in the Federal Constitution, because Article 10, it's meant to cover the right to associate or disassociate generally, not just limited to political parties. And so if you're going to put in restrictions in there, it must be really worded very carefully to say that these restrictions only applies to political party. But then, you know, you run into a further problem of what is the definition of a political party, etc., etc. So for all these reasons, I'd rather not touch Article 10. I would rather have, like, if you want to amend Article 48 or add in a new article to say what will happen if an elected representative leaves the party, that is acceptable for me. But for me personally, don't touch Article 10. That's my 2 cents worth.
Yeah, I mean, Doctor, you raise a very good point. Because 10.2c applies to the right to freedom of association in general, not just in election context. So yeah, I mean, I don't think Nimalan and I will be opposed to amending Article 48. I think that's great. I think I'm more concerned with the specific wording of how we do it. Yeah, because in India and Singapore, if I'm not mistaken, it only covers an individual MP leaving. So it won't cover cases of like Bersatu leaving PH. Yeah. So I think there will still be a legislative or a loophole, constitutional loophole there.
Yes. Mr. Nimalan, do you want to add anything?
No, I was just going to say, I mean, I agree with your concerns about Article 10. And I think our discussions were really centered around that because of the Nordin Saleh decision, which only looked at Article 10. I do have a concern about Article 48 now that I think about it, because Article 48 only looks at members of parliament. So you then don't deal with the state legislative assemblies. And what happens in those situations? Do I then amend the constitution there? Then I still run foul of 10.2. So it may be a situation where we need to include a completely new article, 48A or 10A or something along those lines to address this issue.
Yeah. Okay. Okay. My next question is really hypothetical, but because you are active practitioners, you will know our judges better than me now. So my question is, if we didn't have any constitutional amendments or ordinary legislation on anti-hopping laws in Malaysia, do you think the federal court now, today in Malaysia, would depart from the dicta in Nordin Saleh if the same issue arose again? Should it depart?
Maybe I can go first, sure. Well, not wanting to make any assumptions on what our federal court would do, I do think if it's Parliament that's enacting a legislation that covers both Parliament and the State Legislative Assembly, you then get around that that restriction that I think was Guan Tit Chin in Nordin Saleh who said, 10.2 only applies if a Parliament is enacting it. So assuming Parliament is enacting it, our federal court in the last, I would say, 3 years have been very robust in looking at constitutional issues. I think they have opened up I won't say liberally, but at least widely interpreted our constitution in many cases. And even where they have not, there's always been very strong dissent from the minority. So while I cannot say with certainty that the federal court will depart from Nordin Saleh, I think now is as good a time as any from the composition of federal court judges that I've seen in the last 10 years to have this issue heard and determined.
Okay, but do you think the federal court should depart from Nordin Saleh, or do you think it's actually a good decision in its own right?
No, I think they should depart looking at the definition of public morality.
Public morality.
Public morality, public order. I think it would fall under that exception.
I see. So you're saying party hopping falls under the exception of, in the sense that it is against public morality.
Yeah, I mean, that's what I think at least.
Okay, all right. Yes, Mr. Joshua.
Okay, similar to Nimalan, I mean, we can't say with certainty. I mean, I would agree with him that now is a good time with our current panel, but my concern is, even if the current, we have a recent, let's say we have a federal court decision this year saying, okay, we uphold the constitutionality of a specific act of parliament legislating on anti-hopping. My concern is that down the road, a subsequent federal court may defer. I can give you an example, but it's not an act of parliament case. Like in terms of the basic structure doctrine, we see that a few years ago, federal court very gung-ho, multiple cases. Yes, basic structure doctrine applies in Malaysia. And then last year we see, once we have new federal court judges, they're like, I don't really think it should apply in Malaysia. So I'm quite concerned if we leave it purely to creative judicial interpretation, that we may have a federal court that says, okay, we depart from Nordin Saleh, and then down the road we have another federal court that says, actually Nordin Saleh was correct, we depart from the previous federal court decision. So I think having a constitutional amendment would be the safest, because the judges recognize that at the end of the day, the constitution is supreme. So they will take a position that if the constitution allows it, and if it does not offend any other articles in the constitution, it should, or they will at least try to harmoniously construct that provision to be consistent with other provisions. Yeah.
Okay, thank you very much. Okay, so now I want to talk a little bit about constitutional conventions. These are constitutional conventions are informal and uncodified procedural agreements that is followed by the institutions of a state. They are not enforceable in law or in court. They are best regarded as non-legal rules, but they do in fact regulate the working of the federal constitution. So let me ask you this. Why do you think membership within a party is not enough to ensure that politicians do not hop? In other words, why do you think anti-hopping sentiments are not censured by the parties themselves or by parliamentarians themselves?
Nimalan, you want to go first?
I guess it comes back to the situation of I guess there was a situation of, once I leave the party, what are you going to do to me? What can you do to me? You no longer, strictly speaking, have a reach. Of course, you've had the situations where statutory declarations have been affirmed by candidates and given to parties. And I guess that is one way that the parties are trying to have a control over anti-hopping. If I do recall correctly, I think the legality of those declarations are being challenged right now. I think PKR, at least I recall from the last general elections, had their MP sign agreements that if they were to hop or defect, would pay, I think it was 10 million ringgit compensation to the party. I believe legal suits have all been filed against all of these MPs who leaped during the Sheraton move. And I guess you're waiting to see what the courts say about it. I do think it'll be very difficult for the courts to try and uphold those agreements with Nordin Saleh in play. But of course, again, if that goes up to the federal court, and the federal court may see a reason to depart from Nordin Saleh there and uphold such agreements, we could then see, I think, as Doctor is suggesting, parties themselves being able to censure and hold their members accountable instead of needing a specific anti-hopping law.
Yeah, I think at the moment, political parties at the most can only take disciplinary actions against the members. So like Nimalan mentioned, what happens if the MP or Adun leaves the party? Then the party no longer has any control over that individual. So I think and the good example that he mentioned was in PKR's case. But I agree with Nimalan that I don't think the document signed by the PKR MPs will likely be upheld by the court, especially in light of the Contracts Act and provisions on public policy. So I think the moment there's no strong mechanism for parties to utilize in order to prevent defections.
Yeah. Okay. So like Mr. Nimalan, I think you mentioned earlier that at the moment, all members of a party must vote in favor of whatever the party is, whatever stand the party is taking. They cannot go against their own party.
Just to clarify, I'm not saying that they must, but that seems to be the convention, to use your words, with political parties. I've not really seen any party cross the floor in the last decade at least or so, except I think YB Shahi Samar again crossed the floor, I think about 5-6 years ago, and voted against the motion of the government. And I recall there were discussions about wanting to censure him as the BN backbencher chairperson. So not that they must, but that seems to be how they're operating right now.
Yes, yes. And you are right, because these are not provided anywhere. It's not in any rules, it's not in the federal constitution, it's not anywhere. That is why it is considered a constitutional convention, because it is the MPs themselves who come up with this rule that you must back whatever your party is saying. And if you don't, then we will censure you. So it's like something like peer review, in the sense that you are being judged by your own peers, which is your fellow MPs. The courts are out of it, the people are out of it. It's all being done within Parliament itself. So if that can be done, what I'm trying to get to is, why hasn't the MPs or Parliament as a whole come out to say, as a whole unit of Parliament, come out to say that anybody who defects, the seat will be vacated. Never mind that it is not law, because these conventions are not enforceable anyway. So forget about the law, but parliamentarians themselves come up and say that if you defect, your seat will be vacated. We're going to have a by-election. Why do you think no MP is coming out to say that it's going to be a constitutional convention, we're going to do this?
I think the problem is enforceability. Even if the MPs, okay, let's say I defect. Let's say I'm an MP, I defect, and let's say we have a convention that an MP who defects should vacate the seat. The other MPs may run to the election commission and say, hey, the seat that Joshua is elected on is now vacated. But the election commission say, we don't recognize your convention. And Joshua has not written in to say he's resigning from his seat. So therefore, there's no vacancy. And because there's no vacancy, there's no by-election. I think that's why the discussion is always centered around having either an act of parliament or constitutional amendment to require, legally require an election.
Okay. Mr. Nimalan, do you have anything to add?
I think I agree with Joshua there. I mean, the reason MPs are not coming out to say it is because, I mean, I think if you just look at the current parliament, at least what I would imagine 10% of them or 20% of them are party hoppers. No MP is going to want to come out and publicly say something like this, and then later on hop themselves, which is unfortunately a very common trait in Malaysia, and then get accused of hypocrisy. So I don't think they're going to come out and say that. And the only way we're going to see some change is an actual bill being passed and being enforced on them.
Yes, Mr. Nimalan, I agree with you. In fact, I was just about to say that I would have thought that none of the MPs are coming out and saying that this is what we're going to do in Parliament, because they don't want to bind themselves, because they themselves may want to hop tomorrow.
At some point, yes.
Yeah. Yeah. Okay.
In a utopian society where we had MPs who were full of integrity, I'm sure they would say, okay, if I hop, for whatever circumstance, I will leave my party, and then they will, of course, fulfill that promise. But unfortunately, that's not the case in Malaysia.
Yeah. Yes. Okay. So now we have discussed some of the advantages and disadvantages of having anti-hopping laws in Malaysia. Now I want to focus on what are some of the alternatives to anti-hopping laws. If we don't want to have anti-hopping laws, what else can we do? So my first question to both of you is this. Should Malaysia drop the current first past the post system in favor of the mixed member proportional representation system, which is what is being done in New Zealand, as to guarantee it is the people's choice of representation when MP defects?
So I was not prepared for that question. I do think it does have its benefits. It does have its disadvantages, but I think changing our entire electoral system will require much more detailed study. I mean, I do see the benefits in the New Zealand electoral system, and I think it's something that not just us but many countries. I think I remember England themselves having considered this at one point, especially during the 2010 general elections when they had the Conservative, Labour, the hung parliament. There were discussions of whether they should move to this system. I can't give you an answer whether yes or no, but I definitely do think it's something that we should consider looking into at least.
I'm in favor of reviewing the first past the post system, but like Nimalan, I'm not. I mean, realistically, I doubt it's going to happen. I think it is really a revolutionary wholesale change to our electoral system, and I don't think there's sufficient political will to do that, because a lot of MPs, may not benefit from it. I think now it's very beneficial to them. Let's say 70% voter turnout, and I just need a majority of the turnout. It doesn't even, the majority of the turnout doesn't even have to be 50%. If let's say it's a 3-way fight, 6-way fight, I just have to be the guy or the person who has the highest votes. So I'm not incentivized to change the system that hugely benefits me. I mean, the more people contest, the more votes are split. Either I, as for example, the incumbent, or someone from a well-funded party stand a better chance of winning.
And I think just adding on to what Joshua said, I think now in Malaysia, we are in a similar position to where UK was 15 years ago, where our electoral fights are no longer just 2-way. I think we're looking at least 4 or 5-way contests just through established political parties. And so if you are the incumbent winning those seats, it's unlikely you're going to be winning it with a 50% majority. And then when you're in that position, are you really going to come up with an electoral system which disadvantages me further from what I've been taking advantage of? I would like to believe the answer is yes, but given that we can't even trust our elected representatives to stay in their own party, unfortunately, I think it's unrealistic at this time.
Yeah. Okay. Anything further to add, Mr. Joshua?
No.
Okay. Okay. So the other alternative available is recall elections. So do you think recall elections is a good alternative to prevent MPs from crossing floors instead of having anti-hopping laws, as the voters would have a direct say in choosing the subsequent MP?
In principle, I'm in favor of recall elections, but I'm not sure how it will work in our Malaysian context. I'm not sure we as a democracy are mature enough or prepared enough for such a mechanism, because in recall elections, usually you have a certain number of people, constituents signing a petition, and then the election commission accepts the petition, then the elected individual is removed from their seat, and then there's a subsequent election where the incumbent can actually contest. In Malaysia, with the amount of party politics that we have, I can foresee that if we had recall elections, unless there's some sort of restriction, for example, you can only have one recall election per constituency every 6 months, 12 months, something like that. If not, we'll be seeing it every day. You'll be having certain segments of a constituency dissatisfied with the fact that their party didn't win. They will just gather the requisite number of votes and then, force for a by-election again. So I think in principle, I'm in favor of it, but I'm not sure we are prepared enough for such a drastic mechanism to be in place.
So I'm similar to Joshua. I think I agree with recall elections on a principle basis. And I do think it's a good alternative because instead of automatically having the elected representative vacate their seat if they were to hop. You give it back to the voters to ask, do you want this person to vacate the seat or not? And then you may come to a situation where, like we discussed at the start of today's session, where voters are voting for the individual because of the person itself, and they don't care which party ticket is on, and then you save the cost of having that by-election. Having said that, I do think there are two issues with recall elections. One, which as Joshua touched on, I think we need to limit the situations where it can be held. Maybe only when a party, when an elected representative actually has hopped, and not just any time a party can petition it. And two will be, what are the barriers in place? Because as I recall elections, it's normally a three-step process. You have a petition put first, and then you have an election on whether and recall election should be called, and only then you have an actual election for the seat. So one is this mechanism too cumbersome? And two, what is the threshold at each stage to allow for a recall election to be called? For example, if for the second seat, if you're looking at getting a 50% majority of the number of constituents in the area to allow for a recall election to even be held, I think we're stretching it very far. I don't think we're going to get those kind of numbers turn out. So it really comes to what sort of thresholds are we looking at?
Yes. Okay. So, yeah, Mr. Joshua and Mr. Nimalan, I agree with both of you. And personally, my problems with recall elections is I have two problems with it. The first is, if we look at recall elections in the UK and the US, it is only for situations where the MP has some sort of criminal conviction given against him. It's not for party hopping, So it's something really serious, where the MP has been charged in court, or he's done some serious misconduct or whatever, that you want to have the recall election, not for party hopping. So I'm not sure whether party hopping is a serious enough issue to warrant a recall. That's the first issue that I have with it. The second issue is, in order to have recall elections in Malaysia, we're going to have to amend anyway the federal constitution, maybe our election laws and all that.
Yes, election act, definitely. Correct.
And so if we're going to do that, then we might as well amend the federal constitution like what we discussed earlier, and just say that, if you switch parties, then your seat is vacated or whatever, isn't there?
Yeah, I think.
What do you think?
Yeah, I think completely agree with you. I think recall elections would be a good option in the future once we become a much more mature democracy. Then at least the power's in the voters' hands. We can choose to sign a petition, not just on party hopping. Maybe the MP or Adun has some unethical conduct, maybe not criminal, but very unethical, that we as an electorate, we completely disavow such behavior or something, that we can petition to remove that individual. But I think at the present moment, we're not ready for that.
Okay.
I agree. I do think party hopping is serious enough to warrant a recall election. I think that is where Malaysia may differ from the UK. I don't think, as far as I recall, at least in the UK, we have not in the last 10, 15 years seen that much of hopping going on. And I come back again to the 2010 general elections. I think it was 2010, at least, where there was a hung parliament between the Conservatives, Labour and Liberal parties, and all of them stood strong with their party. There were no MPs jumping from party to party in the UK. I shudder to think what would have happened if that was in Malaysia. So I do think party hopping is serious enough, but I do agree that either way, we would need to amend the constitution and enact new laws. And so the question then really comes is, what will there be more of a political will for among our MPs? Are they willing to risk losing their seat for sure if they were to party hop? Or would they like this, a little safeguard in place to maybe allow them to keep their seat even if they hop, because the recall thresholds are not met? And that was why I was quite excited actually to see what YB Azalina's proposed members bill for recall elections would have looked like. And I think she did a lot of work, if I recall, going to the grassroots, both within UMNO and the wider parties to get support for the bill. Unfortunately, the bill did not see the light of day in that parliament session, and it does not look like it's going to be seeing the light of day anytime soon.
Okay, I'm glad you also brought up the issue that in the UK there's not many party defections, etc., etc. According to a study, I think Mr. Joshua, you were looking at the same study. I saw your table in the slides just now. According to this study, it says that rising democracies, so not really advanced democracies like UK, US, Scandinavian countries, but rising democracies like third world countries like Malaysia, are the countries with anti-hopping laws. The advanced countries actually do not have anti-hopping laws, but that does not mean that defections don't happen there. It happens there, but it is okay for the advanced. I mean, they seem to be okay with it. It is only the rising democracies like us, developing countries like us, which seem to have a problem with people defecting, because I think it really amounts to like causes a little bit of chaos to the political, economic, social stability. And so that is why developing countries are the ones always in favor of having anti-hopping laws. Do you think that is the case, or so do you think like, for example, now if we have anti-party hopping laws, one fine day when we are a developed democracy, we will not need it anymore?
Joshua, do you want to go first?
I don't think it's a clear-cut answer to that question, because it requires us to speculate on how mature our democracy is in the future. I mean, sometimes it's not a matter of time. Like, we could still be in the same situation 50 years from now. You know, it requires a mindset shift, you know, which can happen very quickly, or it can take a very long time to happen. So, but from what I can predict, if let's say we do introduce anti-hopping law, and at one point we become a mature democracy, we no longer need it, I think it will just remain on the books. Yeah, unless there's a huge demand for some reason to remove. If not, we'll just leave it as an act of parliament that exists, but we don't really rely on it.
I think I agree with Joshua. You know, assuming we ever get to the mature democracy stage, we will probably have it still on the books. I don't think we'll see a repeal of it. But like I mentioned, you know, a mature democracy does not mean you have to allow people to party hop, but we need to be able to allow them to cross the floor to vote on certain issues. And I think we haven't even reached that stage yet. So I do think we're quite far away from it.
Okay. So basically, if I can summarize, both of you all are in favor of having some kind of legislation on anti-party hopping in Malaysia.
Yes.
Yes, Mr. Nimalan. Okay, and you think that this is the best way to ensure that party hopping does not occur? By way of legislation, either amending the constitution or having a parliamentary legislation, an act of parliament dealing with anti-hopping.
Based on our current crop of politicians, yes.
I don't know about the best way, but I think it's definitely the easiest way. And I don't think it will stop people from hopping, but at least it holds them accountable to the citizens at large, that there are consequences if you hop.
Okay. Okay, we're coming to the end already. So when you have in this anti-party hopping legislation that you all are hoping will see the light of day in Malaysia, would it just be that an MP who switches political parties, his seat will be vacated? Would it just be that, or would you like to see other punishment as well? Maybe a fine, maybe jail, What do you think?
Um,
See, Mr. Nimalan, because you seem to think that party hopping is a very serious matter, so maybe, you know, the MP should be jailed.
I won't go that far. No jail, definitely. I think vacating the seat is enough. If you want to stretch it a bit further, maybe you can say that he should bear some part of the cost for having the by-election because it's being caused by him. But I do think that may already be a step too far.
Okay.
Sorry,
I would be in favor of vacating the seat plus maybe preventing the individual from recontesting.
Oh, so the same person cannot contest again. Has to be someone else. Okay.
I would disagree there. I think the person should be allowed to recontest only because then you go back to the question of did the constituents vote for the individual or the party? And I think they should have the right to re-choose the same individual, even if he's on a different ticket.
Yeah, I can see the merits in both your arguments, you know, because in the one sense you're sort of penalizing that person for switching parties, isn't it? So if you have such a clause in the legislation saying that, oh, this person, if you switch parties, you cannot stand for election anymore, it will make him think twice about switching in the first place. So maybe the hop wouldn't happen in the first place. But at the same time, what Mr. Nimalan is saying is also very true, which is we then get to see whether the people really wanted that particular individual, notwithstanding whatever party he is representing, or whether they voted for the party. Right? So yeah, there is pros and cons. Okay, so my last question is, do you think anti-hopping laws will get to see the light of day in Malaysia anywhere in the near future?
Joshua, do you want to go first?
Yeah, I think the present government claims they will be tabling it in the current parliamentary session. I'm hoping they do table it. I would love to look at the first draft that they have to see what they have in mind. Are they only limiting it to party-to-party hops, or out of a party hop, or coalition hops are included? I mean, all of these things are very important questions that we have to discuss. Will they table it? I hope so. But we can't say for sure. I mean, they've been talking about wanting a anti-sexual harassment bill for so many years. I think it's finally tabled, but it took many years since I think the PH government time. So they may say, oh, the anti-hopping law is closed, but we may only see it, you know, maybe in the next parliamentary session, or yeah. But I do hope it sees the light of day. I hope it gets the necessary. I hope it's a constitutional amendment first of all, because if it's an ordinary act of parliament, they may pass it through parliament, but it may not survive the courts. So I don't really know what their intentions are. Is it just to fish for votes? You know, just say, yeah, you know, we're completely against party hopping, so we push an ordinary act of parliament, knowing it's unlikely to survive in the courts. You know, is it just for sure, or are they serious about bringing legislative reforms? So it depends. We have to wait and see whether or not, first of all, whether or not it's tabled. Secondly, whether it's an ordinary act of parliament or a constitutional amendment. And subsequently, what are the provisions in that bill?
Well, I think I was like Joshua. I was very excited to see YB Azalina's recall election bill. That was not allowed to be presented in the parliament. Two, I was very excited to see the anti-hopping legislation that was pronounced. I think in January they said they were going to table it in February of this year. It's already March. No sign of it. The last I recall was the minister, Awan Juniadi. I can't remember. I think he's the parliament minister who said there is no agreement on the definition of anti-hopping. So it looks like because they can't agree to it, they're not tabling it. And I'm very surprised to hear that. I would have thought it's very easy to define anti-hopping. And at the very least, it should be easy enough to define it and table it in parliament for debate on whether to expand or narrow the definition as in the bill. So it seems like the government of the day at least is talking about doing it, but there don't seem to be any concrete efforts yet to actually table it in the bill. And I do have concerns whether once a GE is called and a new government takes place, whether this will again be shelved, and we may be talking about the same issues 10, 15 years from now.
I would have thought that the same problem that we discussed earlier about constitutional conventions would also apply to this anti-hopping bill, isn't it? Because I think the MPs will be very worried about, like you said, what is the definition of anti-hopping, because tomorrow it may apply to them. So that is why I think maybe it's taking such a long time to see the light of day in Malaysia, right?
I mean, they can always, like, sorry, go on.
Go ahead, Joshua.
No, I mean, like Nimalan mentioned, they can always table it and debate it. There's no time frame like, oh, once you table it, it has to be passed within, within 6 months or anything like that. They can actually just leave it there, continue to debate, and then, send it to select committees to be inspected further, come back for the third reading and all that. So I think it's just, it could be a cop-out, it could be like, yeah, in principle, we want to introduce it, but since nobody can agree, I guess we can't do it.
I think I agree with Joshua there, I mean, I think the current parliament that we have is probably the best chance we have to actually table such a bill, because we have a coalition government made up of different parties, all who I'm sure don't want to lose their MPs and therefore would like to put something anti-hopping in place. We have a very strong opposition in terms of numbers, at least, who have suffered from anti-hopping and I'm sure would like legislation in place. So I think if we were going to do it, we would be doing it in this parliament session. And I don't know, but like Joshua said, whether it's just window dressing, just to say it, but because we can't define it, we're not going to table it, even though we could actually just define it and debate it in parliament.
Okay, so I'm happy to inform you that I'm done with my questions. We are done with this panel session. Thank you so much. Now we are moving on to the question and answer session. But before I read out the questions, I think one of the attendees, Mr. Selva Raja Murugisu, he has his hands raised. I don't know whether you have a question, sir.
Hello, can you hear me?
Yes.
Okay, this is a very interesting talk by the panelists and the moderator. Actually, when you have a party hopping, my suggestion, I mean, generally they have a by-election which expense to the government and the taxpayers' money. So why don't they have a law which states that the next highest candidate with a vote become the next MP? Much simpler. What's your comment?
I think the issue of cost is definitely something that has to be considered, which is why I suggested, do we want to also look into having the MP who jumps or who hops be the one who bears the cost of the election?
No, that's not the issue. The issue is the next highest candidate becomes the MP once the post is vacated.
So that's the concern I have with your suggestion, Mr. Murugesu, is that you are then not allowing the party that the voters voted for have the seat. You're essentially rewarding the loser, if I may say so, rather bluntly, by giving them the seat. And I take a position that in these situations, you should actually return the right to the voters to choose who they want to elect them, whether on a party or an individual itself.
This is like a check and balance, on the candidates. If at all he steps down, I mean, it's practice in certain countries, I believe in India. So they don't have by-election, it's a waste of money. I mean, it's up to you all to consider, you all the committee. Maybe you can suggest this to the authorities.
Sure. Joshua?
Yeah, I think Mr. Murugesu's suggestion would definitely solve the cost problem. But I think from a democracy perspective, I would be in favor of having a by-election just to allow the constituents to redecide, because like Nimalan mentioned, they could, for example, let's say an MP hopped from DAP to another party, right? The constituents, the majority of the constituents may still favor whoever DAP may feel. So if we were to just decide, okay, based on the previous election, candidate 1 won, candidate 1 hopped, so we're going to allow candidate 2 with the second highest votes to be the MP or the ADUN. and we're not giving the power back to the constituents to decide again whether they want someone from DAP who just hopped. Yeah.
Okay. So something
Thank you for the
to
question.
think about. Something to think about. Okay, thank you.
Thank you.
Thank you so much, Mr. Devaraja, for the question.
You're welcome.
Okay, so now I'm going to read out some questions to you, and either Mr. Nimalan or Mr. Joshua or both of you can answer the questions, okay? The first question is, how would such a law, if implemented, impact Malaysian politics? Such a law being the anti-hopping law, I presume.
I can take this one first. I think it would affect Malaysian politics to the extent that you're less likely to see MPs hopping. I don't know of many MPs who would be as brave as YB Shahi Samad to risk losing their seat and re-standing for election to hold back power, to get back, become MP again. I don't know how many MPs are willing to give up their seat and just leave politics just because they're upset with the party for some reason or another. So I think you are likely to see a huge decrease in MPs leaving the parties, and that may at least, I think, hopefully account for some stability in our politics, or at least some sort of loyalty to a party.
I think depending on the scope of the anti-hopping law, if we're talking purely out of the party, then we'll probably see a lot of disgruntled MPs or aduns just stay in their party because they don't want to lose their seat, or they may form some sort of informal alliances outside the coalition, for example, to pass certain bills. So it will definitely have an impact in the sense that we will see less clear-cut hopping. So let's say the anti-hopping law enacted prevents you from leaving the party. Either you directly resign from the party or you were kicked out of the party. Then we'll see a lot of backdoor dealings to try and circumvent. So I won't officially leave the party. I'll still be in the party, but I will be working with people my party may not ordinarily work with in order to further my agenda. Yeah.
Okay, thank you. Next question is, what would the reception be to an anti-hopping law? I suppose this is hypothetical as well.
I can take this first. I think the public response to it will be very encouraging. I think our public as at least are very fatigued by the constant changes in governments and MPs jumping parties. So I think public would like it, save for, of course, a minority who might feel that it's disadvantageous to their parties. The approach to it from the members of parliament themselves, I think it's hard to say. And I say that given the fact that we still have not seen the bill as of today. Joshua?
I think among the legal fraternity, we'll probably be in favor of anti-hopping law, subject to the scope being properly defined, being a very precise either constitutional amendment or ordinary act of parliament. In terms of on the ground, I think it's quite divided. But what we can infer from political parties across the divide claiming that they are in favor of anti-hopping law, we can probably infer that the general public is in favor of it, because if it was not something that the politicians believe the voters wanted, they wouldn't be doing it because they wouldn't get brownie points. So I think maybe the general public would be in favor of it.
Yeah, okay, so on this point of whether the general public is in favor, I think we discussed it under the social change, right? Whether there's socially there is a strong call for anti-hopping legislation to be in place. And so then I bounced around this idea of whether the fact that there has been consistently low voter turnout in the by-elections and state elections. Could that be seen as some kind of rebellion by the people? So now my question is the other way around, because I think, Mr. Joshua, you said that just because there is a lower voter turnout does not necessarily mean that they are protesting or they want a change. It's not a strong enough call for a change. So inversely, the fact that Parliament is talking about tabling this anti-hopping bill, although nobody has seen it yet, but they're talking about it, and nobody has actually, or no parties, no individual, no parties, no NGOs, nobody has come out to strongly say we don't want it. Is that a good sign? Can that be taken as this is what the people want? They're happy with anti-hopping laws. That is why
it's definitely a positive sign that there's no strong opposition. I mean, we looked at, you can consider things like the ratification of ICERT, Rome Statute, that had very strong backlash from the public. So in terms of anti-hopping law, there's no strong opposition. But I'm not sure we can say the overwhelming majority of the public wants it. I give the example of abolishing GST. I think if the public overwhelmingly wanted it, the bill would already be debated at the present moment. We look at the Undi 18 example, we can see that MPs were lobbied, within a matter of months or years, the constitutional amendment was made. So I think we don't have a political will to that level. We don't see the public really wanting anti-hopping law. So that's why I limited my answer to, I think the general public probably wants it, but we don't have a strong, overwhelming majority of members of the public saying, yes, we want it.
Okay. Anything to add, Mr. Nimalan?
Yes, I agree. I mean, I think the sentiment in the ground is there will be support of the bill, but is it, I think, is it something that directly impacts it or makes it very important to the people? I think the answer is no, which is why we've not seen a huge push for it publicly. In terms of MPs, I think no MP is going to come on and say that they are against anti-hopping bill, at least publicly, because that just looks really bad on them. So, but I think we may be able to infer how some or another may feel of it by the fact that it's taking so long to be tabled.
Yeah. Okay, the next question is, can anti-hopping law guarantee political stability?
I can start first by saying I don't think it can guarantee it, but it can definitely play a role in strengthening it.
Okay.
Yeah, I second what Nimalan said.
Okay. Next question. If you were drafting an anti-hopping bill, how would you define the scope of party hopping, in the sense of what if an MP goes from party to independent or is kicked out of their party?
I can start. I think I spoke about this earlier. I take it as you leaving the ticket that you were elected on, whether it is a party ticket or a coalition ticket itself. What if you are kicked out of the party? I think that is really where the difficulty arises. What if I don't leave the party voluntarily, but if I'm kicked out of the party? I think this requires further discussion. On a very preliminary basis, I think that if you're kicked out of your party, you should also be subject to the laws, only because I see if you don't have this insight, I see it being open to abuse where people may just do everything they can to get kicked out of the party, so they don't have to voluntarily hop and still get to retain their seat.
Yeah, I completely agree with Nimalan. I think if we look at India, we look at Singapore. For Singapore, automatic disqualification when you cease to be a member of, or is expelled or resigned from the political party. Yeah, so that is one model, but it brings up the problems that Nimalan mentioned. Let's say we allow, we do it in the same manner as Singapore, then political parties, due to maybe a fraction within the parties, they could choose to kick certain MPs so as to trigger a by-election in those constituencies. But at the same time, if we don't include kicking as part of hopping, then MPs may just make life very difficult for their political party to the point where they get kicked. But because kicking is not considered hopping, then they leave while retaining their seat. So there's no easy answer. In India's case, they go by way of voluntarily leaving your membership, but Singapore makes it a lot wider. So I think for Malaysia, I think this definitely warrants further discussion. I think there's no easy answer to that question.
Yeah, and then I think in Malaysia the further problem would be, do we also want to include coalition hopping, isn't it? It's not just party anymore.
Yeah.
Yes.
Yeah, that would be a wider consideration which needs to be given some thought, because on the one hand it seems to be really wide that parties are not even free to form coalitions, you know. But on the other hand, because it is happening in Malaysia, maybe we also want to legislate on that. That's another aspect that we should seriously consider, I think.
The coalition perspective would suffer from the same problem if we define hopping to include leaving a coalition. Is it voluntary leaving, or does it include when you are kicked? If you are kicked, do all your MPs and others lose their seat? If so, then no political party will be in a formal coalition. They may be in a informal alliance, you know, where I don't contest where you're contesting, you know, I pinjam my machinery to you, but we are not in a formal coalition, because if we are in a formal coalition, I risk being kicked out and losing all my seats.
Yeah.
So we have all sorts of different scenarios that will result from all the different possibilities.
Exactly, yeah. Anything to add, Mr. Nimalan?
No, nothing.
Okay. All right. Let's go to the next question, which is, the issue of party hopping has been going on for a long time. Why do you think talks of legislating or constitutional amending only arise now? Would you say the Sheraton move was the trigger, or would you say it's due to a more politically aware society?
Joshua, do you want to start?
Yeah, sure. I think it's definitely due to there being a more politically aware society. As the questioner mentioned, all this hopping has happened a lot of times. I mean, 2008 in Perak, you know, and then even recently, you know, happened in Sabah, Malacca. It's very common now, but I think because the public is becoming more politically aware, we're starting to realize, hey, this shouldn't be the case. We shouldn't be allowing our elected representatives to do this to us. This is a complete affront to the mandate we gave them. So then now we are starting to push our MPs or push our aduns to consider anti-hopping laws. But it definitely has been around for a long time. I mean, like we see Nordin Saleh's case, 1992. The Kelantan state legislature saw it fit to include such a constitutional amendment. So it definitely has been around. I won't say Sheraton move is the trigger, but it's probably the most prominent one because it's on a national level. Compared to all the previous examples of states, state governments changing.
So I partly agree, Joshua. I think it is a more politically aware society, combined with, I think the Sheraton move was the trigger, because we saw such a huge number of MPs jumping. Unlike, I think Perak was just 3. Sabah in the 1990s was, I think, 5 or 6. So now we've seen so many MPs jumping at a time where the country actually had, I guess, 2018 was sort of the change in the country where we could see that there were actually possible for changes of governments, and we expected a more mature democracy moving forward. And then to see it go back where we thought our country was progressing to, I think both these factors combined has led to a larger call for anti-hopping legislation. Of course, along with the fact that even since the Sheraton move, they're getting more and more news of MPs leaving the opposition, opposition leaders having press conferences saying that government MPs are jumping to support them, and this whole instability of government. I think it's these 3 factors combined that has resulted in more and more people wanting to push for some sort of legislation to be enacted.
Yes, I agree with you. It's something like World War I, isn't it? There were so many triggers to World War One, but the immediate thing was the assassination of Archduke Ferdinand, I think. So I think the Sheraton move was the immediate thing that caused people to call for anti-party hopping, although there were already so many triggers before that.
Yeah.
Right, so it's not just any one thing, but a combination of everything. The last straw that broke the camel's back, I think, was the Sheraton move. And like Mr. Joshua said, because it happened on quite a large scale on a national level, and it caused the change of the entire federal government. So I think people said, you know what, enough is enough. Right, okay, next question. If Malaysia were to legislate an anti-hopping law, how would it be balanced between the MP's party mandate and the freedom of party members to dissent from the opinions of their party? Wouldn't it be bad for a parliamentarian to move away from a party that no longer represents their political views?
So I think the first question, the first stage at least of the question is, I do take this belief that just because I'm a member of a party does not mean I'm bound to vote in support or against a motion based on the party line for every motion. I think there are some motions which you have to follow the party line, like the budget, for example. I think in the UK, there's policy, they call it the 3-line whip. While if you're like a 2-line or a 1-line whip, you are allowed to cross the floor and vote for or against motions. I think this is what happened in, was it 2019 when Boris Johnson tried to promulgate parliament? I think a number of Conservative MPs voted against those attempts. So I think we do need a mature democracy that where you are allowed to cross the floor to vote on certain motions, and that shouldn't be a reason for you to have to vacate your seat or leave the party. So we have to get there. But if you're looking at the wider context of if I no longer support whatever my party stands for everything, should I not be allowed to leave the party? The answer is yes, you are allowed to leave the party, but it has to come with the consequence of you re-standing for election and seeing whether the voters agree with your views about the party or not. Joshua?
Yeah, I agree with Nimalan. I think it is definitely a balance, a very fine balance that needs to be threaded. So if we adopt, for example, Singapore's provision in the constitution that says you're automatically disqualified even when you're kicked out of a party, then that will definitely quell party dissent, because MP will feel I have to toe the party line. If not, I risk getting kicked and having to vacate my seat. Yeah. So then, would such a provision, thread the balance? Probably not. Yeah. So it all boils down to the scope of anti-hopping. How are we defining anti-hopping? Only voluntary cases of MP or adun voluntarily leaving the party, then perhaps that will leave some room for dissent within the party, because the party can't punish the MP by kicking them and therefore automatically disqualifying them. Yeah.
Okay, so following up from what both of you have just said, are you saying that in order for there to be a proper anti-hopping legislation in place, that same legislation should also include allowing MPs to cross the floor without any repercussions? Because if you allow them to vote against their own party without leaving the party, it is actually consistent with how the anti-party legislation should be. But is that what you are suggesting, that in that legislation you have these two parts? Don't hop, but you're allowed to cross the floor.
I don't think you need to legislate that aspect at least. I think because I can vote for or against my party's motion without leaving my party. So I don't think you need to put that in the legislation itself expressly, but I think it's something that our political parties should be aspiring to be more mature. And I go back again to the example of YB Shahid Samad in 2006. I think when he voted in favor of an opposition's motion, he never had to leave Barisan Nasional. Although I do believe he resigned as the chairman of the Backbenchers Club because his party was not happy with him supporting an opposition motion. So I think that aspect of it has to be moved away. We need to allow our MPs a bit more freedom to vote on certain motions, at least according to their conscience, without having to leave the party or be censured.
Yeah, I think legislating is definitely one option. But then, is it going to be an exhaustive list, a non-exhaustive list? What will be on that list? I think it's a lot easier to leave it to the parties to self-regulate, to basically be more mature and allow for their MPs to differ from the party position. Maybe at the most, they are subject to disciplinary action, which is presently the case.
Okay. Okay, second last question. If implemented, do you think the speaker should be empowered to disqualify an MP on the grounds of defection? Or do you think this is an overreaching of power? Depends who the speaker is aligned with also, isn't it?
Correct. I think I would be in favor of letting the election commission decide, since the election commission is supposedly independent, whereas the speaker is generally a political appointee by the government of the day. So I think it's best to leave it in the election commission's hands. It's definitely an overreaching power for the speaker to, especially if there's no check and balance. If the speaker announces, okay, you have defected, but the election commission has to verify and agree with that, then I think it's not too bad. But if you're leaving it purely to the speaker could just be like, okay, you defected, clear your seat, and then by election. Yeah.
I think I agree with Joshua. I don't think we need to. The speaker shouldn't be involved. I think it is a question of the political party maybe notifying the speaker, and the speaker just has to pass on the message to the EC instead of exercising his or her own discretion.
Yeah, okay. Okay, so now we come to the last question, which is, would any anti-defection law empower political parties in an already loyalty-based political environment?
Sorry, could you repeat the question?
Would an anti-defection law empower political parties in an already loyalty-based political environment?
The answer is yes. I think you would definitely be empowering political parties. So I guess that is where I say it has to come hand in hand with a bit more mature democracy, allowing MPs to, well, political parties to, at least by conventions, are allowing their MPs to vote according to conscience, but at the same time knowing that they will always retain the support of the parties in the event of big motions, or not ensuring that they're not leaving the party. At the same time, I don't know if I would so agree to the extent that loyalty to a political party is paramount now, especially given how people are hopping left, right, and center. I think it's more loyalty to power and perks than any particular party or ideals at this stage. Not all MPs, but a sizable number.
Yep, I agree with Nimalan. I think the answer is yes. Back to the scope. If it involves kicking, I think definitely. If I was an MP and if I risk losing my seat if I got kicked, I'm going to toe the party line, 100%. You will see me as the most loyal MP on any of the motions that my party is taking a position on, because I don't want to get kicked. I don't want to lose my seat. So if we adopt the Singapore provision or equivalent to the Singapore provision, then definitely it will empower political parties.
Okay, so we finished with all the questions. Do you have any last concluding remarks or insights to share before we wrap it up?
Nimalan, you're muted. Nimalan, you have to unmute.
Sorry, I thought I pressed the unmute button already. I think I can just conclude by saying, I think some form of anti-hopping legislation is necessary in the country to at least hold our elected representatives accountable for their decisions and choices, and to give the voters the right to make their decision. I think this really is the best time for us, if any, to get such legislation passed. And I'm hoping that our MPs can all come together and we will see a bill, if not this month, at least by the next parliament session, before parliament is dissolved for the next elections. Joshua?
Okay, thank you.
Yeah, I think it's a very important topic, and I'm glad that UMCT and Bar Council's Constitutional Committee can have this discussion today on this topic. I do hope that the federal government pushes something through, and that if it is a good bill, that the MPs, there'll be bipartisan support and they'll be able to push it through, knowing that this is what would be good for our democracy, what would be good for Malaysian politics. I think it's just a matter of waiting and seeing whether it will actually materialize, and if so, whether the bill will be what we hoped it would be. I think if you look at the IPCMC bill, it was drafted a particular way. Civil society was very much in favor of it. The Malaysian Bar was in favor of it, but now it's been watered down significantly. So one step is to get it tabled first, but the next thing is to assess its effectiveness, because if it's just going to be an act of parliament on our books, but it does not address the problems that we have, then we might as well not have it. Yeah, so I think hopefully they do table it, then we can dissect it in detail and maybe have a subsequent webinar to look into the merits of whatever's being proposed.
If it ever materializes,
If operative word is if.
Yeah. Okay, so that's it for our panel session today. I wish to thank Mr. Joshua and Mr. Nimalan so very much for taking the time out on a Saturday morning to share all their valuable insights and inputs on this matter. I'd also like to thank all the attendees for your questions and for your attention. Thank you so much. So now I will cross the floor, pass the floor back to the MC, Mr. Brian. Thank you.
Thank you so much, Mr. Nimalan, Mr. Joshua, and as well as Dr. Sheila for the insightful discussion. I'm very sure that all of the attendees today have learned a lot from the input given today. Now, the debate on anti-hopping laws has been a long-running one in Malaysia, and as such, it is important for all of us to remain informed and aware of what anti-hopping laws mean for Malaysia as a whole. But with that being said, we are now nearing the end of this event. So now I'd like to pass the floor to the director of the UM Consti Team, Ms. Ashley Voon, to say a few words.
Thank you. As mentioned by Brian, my name is Ashley Wood and I'm the director of UM Consti Team. At the outset, we would like to apologize for the disturbances earlier. This is our first Zoom bombing encounter and we are terribly sorry for the interruptions. Rest assured, we will take note of this and implement better protective measures in our next event to prevent such interruptions again. Moving forward, before we conclude today's session, I must extend my gratitude to several stakeholders who have contributed to making this event a success. Foremost, I would like to thank our guest speakers, Mr. Nimalan Devaraja and Mr. Joshua Wu. Both are here not only as lawyers from Skrine and Messrs P. Lim, but also as representatives of the Bar Council's Constitutional Law Committee, who share the same passion and enthusiasm as we do in constitutional law. We decided on this topic because it piqued our interest, particularly due to the political climate in Malaysia. We find ourselves wondering whether there is any possibility of introducing anti-hopping laws in our country and the implications that would ensue from this. I thank the speakers, Mr. Nimalan and Mr. Joshua, who have managed to demystify and elucidate all there is to the subject. We are highly appreciative of your dedication in imparting knowledge regarding anti-hopping laws to our audience. Second, I would like to thank our advisor, Dr. Sheila, for moderating today's session. Thank you so much for supporting the UM Consti Team in all of our ventures. Your relentless support and guidance is invaluable to us. Third, I would like to extend my gratitude to all of the participants. Thank you for attending today's session. I hope this has helped dispel doubts and uncertainties that you had regarding anti-hopping laws. And last but not least, I must thank all the UM Consti Team members for your hard work and contribution. It would not be possible to organize an event like this without your level of commitment and dedication. We look forward to welcoming all of you again next week for the death penalty debate webinar. With that said, I will conclude my speech here. Thank you once again and have a good day.
Thank you, Ms. Ashley, for your speech. Once again, the UM Consti team would like to extend its sincerest appreciation to our distinguished speakers and moderator for the informative session. We also thank all participants in this Zoom call and on our Facebook Live for tuning in. Before we conclude today's session, let's commemorate this event with a quick photo session. I would like to invite our dear speakers, moderator, and all participants to turn on your cameras. I shall pass the floor on to our assigned photographer to conduct the session.
Hello everyone, I'm Jade, your photographer for today. I would like to ask everyone to kindly turn on your cameras for the photo session. Has everyone have their cameras on? All right. Still waiting. Okay, I think that's about it. I'll be taking the picture on the count of 3. 1, 2, 3, smile. Okay, I'll move on to the next page. 1, 2, 3, smile. Thank you. I shall now pass the floor back to our MC.
All right, thank you very much. We are also pleased to inform all participants that Mr. Joshua has so kindly provided us with the slides he prepared for our reference. The slides are accessible via the link that will be sent in the Zoom chat, and we hope you find them as useful as we do. We would also like to kindly invite all participants to fill in the feedback form by scanning the QR code displayed on screen or by clicking the link sent in the chat box. Your feedback is greatly appreciated. Now, this marks the end of the panel session today. Thank you once again for all of you spending your Saturday morning with us. We hope you have gained tons of insight from today's session, and we hope to see you for future events. Do join us next week for our webinar, Execute Justice, Not People, the Death Penalty Debate, to catch Emeritus Professor Dr. Shad Salim Faruqi, Dr. Malik Imtiaz Sarwar, and Adjunct Professor Mr. Philip Ko Tong Yi as they explore the topic of the death penalty in Malaysia. Now, take care, stay safe, and enjoy the remainder of your weekend.
Thank you very much, Dr. Sheila.
Thank you so much for taking the time to come today. Thank you. Actually, we can leave, right?
Yes, Doctor. Thank you so much.